court and my opportunity to have served there. That court as well tested my patience. It grew my muscles as well for endurance. Endurance that enabled me work under extreme pressure. In that court, we were able to pilot the court recording and transcription. Court recording and transcription that was then being introduced. And I was given the opportunity to serve as a chairperson of the subcommittee on court recording and transcription. In that time as well, the judiciary was keen and anxious to introduce ADR and alternative justice systems and mainstreaming it for purposes of access to justice. I, along with other colleagues in that division, were able to pilot that process, one that was then embedded after COVID-19. My Lady the Chief Justice, you have mentioned the multiple jurisdictions that the Supreme Court has been granted by the people of Kenya. I just take three that are very commonly known. My lady and eminent commissioners, in my life as a judge of the High Court and the Court of Appeal, I have been involved in hearing and determining electoral disputes in at least 3 election cycles. I think I have the necessary knowledge. I have gained the necessary experience that has been noticed by no less, I hope, you, my lady, the Chief Justice, who in your prerogative appointed me to serve currently in the Judiciary Committee on Elections, where I head the subcommittee on law reform. Kenya stands at a special place, commissioners. We are at a point of economic development that is evolving, that requires the embrace of technology. There are new areas of disputes that will emerge that will reflect this new emerging socio-economic order. Questions of carbon credit, issues of our place in fighting cybercrime. I do believe that the new emerging areas, the new areas of the law, including those that will be presented by a shift now in demographics, will emerge as new areas of general interest litigation. I have been presented with the opportunity in service at the High Court and the Court of Appeal to demonstrate, I hope, and I hope you will see this through the decisions I have presented, that I have the curiosity to delve and engage in new emerging areas of the law. I would hope that you find it fit and kind enough to consider that I would be an invaluable member of the court or an addition to the court in respect to the second appellate jurisdiction of the court, which is to deal with appeals involving matters of general public importance. Lastly, and shouldn't be the least, is the question of the mandate of the court in terms of constitutional interpretation and application of the Constitution. My journey in the judiciary and my tenure both at the Court of Appeal and at the High Court has given me an opportunity, which I think is a very kind opportunity to get involved and to hear matters that require constitutional interpretation, some of which are very high profile, some which have been emotive and contested. I do believe, and I ask that you find in your kindness, commissioners, that the work I have done, the decisions I have made, demonstrate some intellectual vigor, flexibility that would enable me make a contribution to one of the greatest courts that we have in Africa.
Thank you.
May I, Your Ladyship,
yes,
and the commissioners, say that if I was granted the opportunity to serve at the court, I hope that I can be a befitting replacement to my friend and brother, Justice Ibrahim.
Very well. That's a very good introduction you have done. I want to ask you one more question before I hand you over to my colleagues. I want to know what is your judicial philosophy? And when you tell us your judicial philosophy, I would like you to take one case which you have done to demonstrate how you have applied that philosophy in actual determination of a real-life case, so that we can know and gauge your ability to deal with the complex cases.
Thank you, thank you. My Lady Chief Justice Muganga Hajigangi. And when we sit as judges and judicial officers, we don't sit to first think, oh, this is my legal philosophy before determining or hearing a matter or giving direction. But the public nature of our work is such that our work will be criticized. There will be scholars who will make comment on our decisions. Engaging with certain scholars who have read my decisions, they think that I belong to the school of judicial pragmatism, one where I approach matters from a pragmatic perspective, which requires that I give solutions to matters that come before me, be they be novel, but interpretation that is impactful, one that tries to find purpose in the law. So that, my lady, is my philosophy. Mm-hmm. Of course, there is no one, you can't fit it in pigeonholes, because sometimes you are confronted with different matters, and you might want to look at matters from a different perspective. Mm. My lady, if I could attempt to the second question about what decision could demonstrate my philosophy. I had in my tour of duty in Busia, confronted with a matter that required a division of matrimonial property. It seemed like a small, mundane matter. There was a contest between estranged couple as to the distribution of the property. You will see from, it is one of the writings that I submitted. These were the early days in respect to interpreting the section dealing with the rights of, in respect to matrimonial property. I believe that I gave a solution that shows that I was thoughtful in respect to the impact of my decision to the parties that were before me. It required that I interpret the provision in the Constitution, and my lady, in respect to the resolution that I gave, I found that the contribution of a married woman, and therefore her share in matrimonial property, must be gauged from her contribution, never mind whether it is monetary, it could be in terms of non-monetary contribution. In the end, the approach I took, I think, has been vindicated by this court, by the Supreme Court. Thank you.
In the case of the Ogen Toto?
Yes, yes.
Very well. I will now move on to give this opportunity to Justice Commissioner Sishale to take it from here.
Thank you, Honorable Chief Justice. Honorable Tuyot,
Yes.
long before the promulgation of the 2010 Constitution, and whilst you practiced law in Eldoret, the position of the law was that it did not matter how evidence was obtained. The sole consideration for the admissibility of the evidence was whether the evidence was relevant. Am I correct in that summation?
Yes, I would think. Generally, yes.
Yes, generally. Now, the position has since changed, and the Supreme Court, which you seek to serve in, has departed from that position to the extent whereby the main consideration these days is how was this evidence obtained. By way of illustration and citing the cases that have been decided by the Supreme Court, can you take us through this journey?
Thank you. I think, my lady, you have tried to contrast the position prior to the new constitution and after. The consideration prior to the new constitution was the question of relevance of the evidence, the question as to whether it can help resolve the matter or the dispute before the court. The shift has been informed by the heightened to the prominence of questions of good governance and Article 10 have been brought to bear, so that whoever is obtaining the evidence must be wary of obtaining that evidence using illegal means or unlawful means. I had the opportunity, my lady, when we were considering the matter involving the DCJ in a 5-judge bench, to consider that question. And our position, the position we took, is what you have just stated, that where there is a breach of a fundamental right which impacts negatively on the administration of justice, so that it's a bigger picture. It's not just about the individual whose privacy has been breached, but its implication on the general administration of justice, then the courts would shut out that evidence. Of course, it is still controversial, because I know that in the UK there is a tendency for the courts to fall back on the old position. I am not too sure that I can recall any of the Supreme Court decisions in that respect.
All right. The decision that you referred to, the matter of the DCJ, was a criminal matter.
Yes.
What about in the area of civil law? Any decision that come to mind?
In the area of civil law?
Yes.
Must it be from the Supreme Court, my lady?
Supreme Court, yes.
Okay.
We are confining ourselves to
Okay.
this Supreme
all right,
Court.
All right. No, I can't recall any.
All right. The Njonjo Mue case, does it ring a bell?
Yes, it does. It does.
What did the Supreme Court say in that matter?
The Supreme Court held that because there was a breach of privacy of the litigant, then the court needed to frown upon parties taking shortcuts in respect to obtaining evidence.
So that I've given you one case, another one?
I cannot recall.
What is famously known as the SGR case? SGR case, Kenya Railways Corporation versus Okiya Omtata and others.
No, that doesn't come to me.
It doesn't ring a bell.
Yes.
So in your own view, this question of whether evidence is admissible being pegged on how it was obtained, do you think that that is a fair state of affairs?
One of the considerations that I would give as a judge confronted with that question is the nature of dispute and the impact of the evidence that has been shut out. If the dispute that is before me is one that involves as well the rights of other people in terms of fundamental breach, and the infringement can be redressed or remedied in another forum, then I think there would be a question of balancing. Has the evidence that has been shut out, what impact does it have on arriving at a fair decision in the matter that is before me as a judge?
All right, Judge, I hear you. But let's take the matter of Kenya Railways Corporation versus Okiya Omtata, the SGR matter.
Yes.
Where documents had been tabled before committees of parliament. And this, of course, involved the construction of the railway, and it was a matter of public concern. And the Supreme Court did say this evidence was obtained irregularly, hence not admissible. So given what you're telling us, the considerations that you are saying you'd have to put into effect as you're considering this matter, so given that kind of scenario, where there are documents that have been tabled before these committees, it's a question of construction of the Kenya Railways, and it's a matter of public interest. Would you then still say that how this evidence was obtained would come into bear in the decision that you would be making?
In respect to that scenario, I would have to consider that there is the access to information provisions. And so one would need to weigh what was the circumstances. Did the person who obtained this evidence attempt to utilize the lawful avenues available by the law, by the legal framework, to actually obtain that information? I do not know the factual metrics of the matter that you cite, but one question that I would be asking is, why did the petitioner, if it was public documents, never utilize the access to information provision of the Constitution, which is now statutorily embedded?
All right, we leave that issue, but of course the question here, you seem to be saying that as far as you're concerned, the main consideration would be, we would be departing from what used to obtain before the 2010 Constitution, and we would have to focus on how the evidence was obtained.
Yes.
That's what you're saying. Now, let's move to another area, and the area of locus standi. What was the position before the 2010 Constitution?
On locus standi generally, or in respect to what area?
Generally.
Generally.
Yes.
Now, and I think I can give this illustration by looking at one of the early environmental law litigation matters, which I think involved Professor Wangari Maathai, where the courts were quick to shut out the petitioner, citing lack of locus standi and a direct interest in the questions that had been raised. The Constitution of Kenya has now widened that the provisions of locus standi, where in respect to certain grievances, any person can stand in the place or on behalf of not just the litigant himself, but the public generally. So there's been an expansion of the doctrine of locus standi, and this follows the trend elsewhere in progressive nations, where it is recognized that to shut out or to narrow locus standi could lead to certain grievances not being addressed. For instance, intergenerational concerns in respect to the protection of the environment.
All right. So, of course, the position radically shifted after the 2010 Constitution, that now the question of whether you can file a case, whether you have the capacity to file a case, was greatly widened, as you say. Now, there are critics who argue that the Supreme Court, in spite of what the Constitution has said as regards locus standi, has consistently but surely moved towards a direction of constricting the doctrine of locus standi. Do you agree?
Thank you, my lady. I am not certain that that would be an accurate statement, and I'm not alive to any decisions that demonstrate a shift towards trying to stifle locus standi.
I can give you examples.
Yes, please.
There is the case of the Methodist Church versus Fugicha, and also the case of Mastermind Tobacco Limited. And here, the issue at hand was the role of an interested party in a suit, and the Supreme Court did come to a conclusion that if you're an interested party, you're bound by the pleadings of the principal parties, and that you are not a co-driver in that litigation, hence you cannot introduce issues that the principal parties have not pleaded. So the justification from the critics is that these two decisions have surely but consistently tried to stifle the doctrine of locus standi as now provided for in the 2010 Constitution.
Yes, I'm aware of the Fugicha decision, and of course there are different views in respect to that decision. I would belong to the school that endorses it as perhaps the correct position of the law in respect to interested parties. The question I would be asking myself is, this was litigation, no doubt, which touched on constitutional interpretation and application, but it was driven by particular petitioners. My concern would be whether the interested parties themselves had a specific grievance and whether they could not have moved the court themselves. I do not think that merely insisting that litigation properly belongs to the main parties and that the interested parties have no doubt an important role is nevertheless peripheral, necessarily constricts on the doctrine of locus standi.
Thank you, Judge. That's all from me, Honorable CJ.
Thank you, Commissioner Mwanza.
Thank you, Chief Justice. Judge, just so that I I want to pursue just like a bit about what Justice Charlie has raised about locus. Mm-hmm. Now, if you read Article 22, yes, 22 of the Constitution is about enforcement, mm-hmm. and that is the article that dealt with the locus standi. And it says that every person has a right to institute court proceedings claiming that a right or a fundamental freedom in the Bill of Rights has been denied, violated, or infringed, or is threatened. And more importantly, if you look at 22(2)(a), it says a person acting as a member of or in the interest of a group or class of persons. So I don't know what your view is. If somebody is acting in the interest, mm-hmm. then don't they stand at the same pedestal as the main party? So that what Justice Charlie is trying to raise, if you look from the beginning, we had Muma Matemu, which said you just need to demonstrate a stake. Then now you come to Fugicha, Mastermind. Then the latest decision is, I think, the one on Mzima Springs, where the Supreme Court seems to be clawing back that very particular interest that is set out in the Constitution. So then I don't know what your view is, yes, in view of saying that the Supreme Court seems to have taken a conservative stand on those who act in the interest of others, because it's clearly set out in the Constitution.
Okay. Let me attempt to looking at the import of Subarticle 2.
Yes.
In addition to the person acting in their own interest, may be instituted by a person acting on behalf of any person, not act in their own name.
Yes.
I think that provision in my reading is very specific. This might be, for instance, in respect to filing or urging a matter by one person in respect who has been disabled by whatever nature, either because of age or mental capacity or mental state, to bring that in their own name.
Okay.
Secondly, if I could just pursue that, is that there is a place for class action within the architecture of our litigation, so that if someone wants to start a class action, there are procedures in which all those who are interested can mainstream their interests within that litigation. I do not see a contradiction between the position that has been taken by the Supreme Court and the questions of locus standi, because there are other provisions which no doubt have their place in terms of fair hearing. There is a respondent to respond to proceedings in terms of what is it that they have to answer, what is it that has been pleaded, the case that they have to confront. There are other avenues in which such interested parties could mainstream themselves very early on in the main dispute.
Okay. But Judge, if you look at 2A, 2A, there is at the end of it, there is a semicolon, and then 2B stands on its own. It doesn't read as one and the same.
Absolutely.
So that 2B says, in the interest of a group of persons. And where you answer that, what, in your view, my Lord, is the value that interest group brings to judges or to our court, particularly such a court of high standing as the Supreme Court, in public interest matters?
Okay. Thank you. Thank you, Commissioner. When my initial response was in respect to 2A,
yes,
in which I attempted, I hope,
yes,
that I was clear on this, that in fact, in respect to 2A, it talks about bringing litigation on behalf of those who cannot bring in
yes,
their own names,
yes,
perhaps minors,
yes,
perhaps
yes,
people incapacitated any other way, distinguished from B, which is in respect to the class action, which I spoke as an alternative.
Okay.
Let me just get your second question correctly.
My second question is the purpose of interest groups, particularly in high stakes litigation, and what value they bring to the Supreme Court.
Interest groups.
Yes, interest groups, because you have many interested groups. I mean, the Supreme Court belongs to Kenyans.
Yes.
It's a court for Kenyans, and it's a forum for them to present their views, in my opinion, about what they think is at stake or what affects them. So, what value do they add to litigation at the level of the Supreme Court?
Yes. The Constitution of Kenya acknowledges the diverse nature of the people of Kenya. The people may choose to organize themselves in certain groups, perhaps because they feel they have similar interests, similar values, and the interest groups would be important in informing, in respect to a matter before the Supreme Court, the different shades of concern, the different views in respect to a matter that could be before the Supreme Court. It will help give the Supreme Court a broader view of a matter that is before it, so that in determining a matter, it does not focus on the parochial or narrow question that may be before the court. I say this because of the importance of the Supreme Court as the highest court, one which is not just a teaching court, but one that needs to guide all the courts below it. So there is certainly an importance of the interest group views.
Okay. And just lastly, though this was not my question,
Yes.
in terms of where a matter comes before the court and the court is not very familiar with it, perhaps a matter of Islamic law, and there is no any other voice outside the main parties, and the court perhaps would want to know, a little bit more about a subject matter or a practice or culture or religion, can the court invite on its own motion, if there is no interest group or any, say, amicus, an expert or somebody to stand in and perhaps shed some light on a difficult subject?
Thank you. If I recall the Supreme Court rules and the place of amici,
Yes.
I'm not too certain. I think that the court can invite on their own motion. I'm not too sure.
Okay.
But it seems to me that it could be sensible, the manner of identifying who to invite
Yes.
is a question, of course, that would be out there.
All right, thank you. Now,
Perhaps if I could ask, am I right on that?
actually, it's not been settled. I don't think it's been settled.
Okay, all right.
Yeah.
Okay, so the debate goes on.
Yes.
Thank you.
Now, in the case of Kamau versus Attorney General and 14 others, a 3-judge bench ruled that criminalization of FGM, where adult women consent, did not violate the right to dignity, religion, or freedom of choice, amongst other fundamental rights. And a 3-judge bench again held that criminalization of FGM while permitting male circumcision did not amount to unreasonable discrimination. Now, in this case, ultimately, the High Court, in its determination, upheld the prohibition of FGM, of the FGM Act, which prohibits FGM, and directed the Attorney General to forward to Parliament amendments to the Act with a view of prohibiting all harmful practices of FGM. Now, my first question is, if you can perhaps elaborate what your view is about what the High Court grounded its decision on to prohibit all forms of FGM on a goal-based legal theory or a right-based legal theory. Because if you look at the FGM law, it does not seem to be, gender neutral. It seems to be the dominant view that, we think that an adult woman, perhaps, who consents to even, say, cosmetic procedure, does not have a choice.
Okay. Thank you. Let me seek this clarification because I was not aware about the case.
Yes.
Did the court outlaw the FGM statute that prohibited? What was the position of the court, so that I'm clear?
The court ruled that if I get it right, that criminalization of FGM, where adult women consent to eat, did not violate the right to culture, dignity, whatever, religion and freedom of choice, among other fundamental rights, but it held that the FGM Act, the Anti-FGM Act, prohibited harmful cultural practices. Mm-hmm. Yes.
Okay. Thank you. First, one must begin by appreciating the place of personal autonomy in terms of, or in respect to one's body. If I was a judge confronted with the question of the practice of FGM, I would have to understand the purpose of the statute and the historical perspective. Where is the country coming from? There is a question about the consent of the adult, and so that it would seem that we should not be concerned once an adult of female gender chooses to subject herself to FGM, then we shouldn't be worried about that. But there's this whole question about what is consent? What is consent? Is this true consent? Is this consent that is pressurized because of cultural views? Is it one of societal views or pressure? And so it's a difficult question, but I would be interested in interrogating whether the statute deals with the question of consent.
But Judge, if you look at the article on freedom and security of a person, actually some scholars seems to suggest that that article says that it is a right to be left alone.
I know, Commissioner.
Yes.
And we must never lose sight, and Justice William Tunga Emeritus always reminded us of the need to interpret the Constitution bearing in mind the history of it, and to come up with indigenous and truly Kenyan jurisprudence. I am not too sure that, given our history and our place in that journey, whether we should treat the question of consent like, say, a court in the UK would treat it.
Okay.
So it's a debate, and I'm willing to be persuaded that my view is one that is wrong.
In fact, there is an interesting act known as the Protection of Traditional Knowledge and Cultural Expressions Act, which provides that a person's fundamental right to participate in their cultural life of or his or her choice should not be taken away.
Yeah. Thank you, Commissioner. I agree.
Yeah.
But what is culture? Is culture that was there in 1930 the same as culture today? Is culture static? Is it evolving? I'm not too sure that we should be blind to the realities that informed the representatives of the people of Kenya in Parliament to legislate in the manner in which they did.
But what is the
in respect to the FGM Act?
Yes.
In respect to the FGM Act.
Yes. But what is the business of a court in the private affairs of an adult?
The interest of a court is to give interpretation to that right that is truly purposive, one that would give full effect to the right. And again, and I'm sorry I seem to be digging in on these, the question of consent and the place of history in the matter.
Okay, thank you. Now I want to ask you another question. Judge, there is a case by the Supreme Court,
yes,
known as Jovet Limited versus Bavaria, whereby the Supreme Court restated the principle that obligations of the court has on obligation, and that is not discretionary. And the court also said that the position of the law is that a court ought to resolve a dispute that reflects on the value of the Bill of Rights, that underpin the Bill of Rights, and then it integrates it into its own decision, so that there is a duty to decide on courts. Actually, it's one of the values that the Supreme Court seems to develop lately, on a duty to decide by courts. Now, I want to take you to your case, a case that has received a bit of criticism by scholars, especially those who practice arbitration law. The case of University of Nairobi versus Multiscope, which Your Lordship decided on 13th of May 2020, when you are sitting as a judge in the commercial court. In that case, the criticism is that, Your Lordship, you did not give the University of Nairobi an opportunity to challenge an arbitral award on the basis that the university had been notified of a publication of the award through a letter, but had not instituted legal proceedings within 90 days stipulated from the date the award was delivered. You took the position that the award was deemed as delivered to the parties when the parties are notified of the award is ready for collection. And this is how you delivered yourself, my lord. If I might just quote a small paragraph of that decision. You say that a plain reading of the provisions do not require the arbitral tribunal to send or dispatch the signed copy of the award to the parties. And at the end of that ruling, you've dated, signed, and delivered it. That was, I think, in Eldoret on 13th of May 2020. Now, my lord, so I'll ask now follow up the questions. I think you've gotten the context.
Yes, I do.
All right, thank you. When a court delivers its judgment, a notice normally sent or dispatched to the parties or their lawyers on the date of the delivery. Now, in your view, does the notice of delivery of the judgment equate to the delivery in question? That is the first question. Can I pose them so that you answer them together?
Please do.
Okay.
Please do.
Then the second one is...
no, I thought you'd said pause.
Yes.
You could pause there.
Oh, I pause
so that
there.
I take
Okay,
that.
right.
Yes.
Should I...
Pause there.
I pause there.
Yes.
All right, thank you.
Thank you. Thank you. I was hoping I would not have to discuss this decision at all. I say this because recently, seated as a third member of a bench, we certified that this matter is requires further interrogation at the Court of Appeal. And I look forward to hearing what the Court of Appeal would say.
The Court of Appeal or the Supreme Court?
No, it hasn't come to it's at the...
it's the Court of Appeal.
Yes,
yes. So it's a live matter.
Yes.
So I don't need to go into it.
Yes. No, it's up to you. I'm happy to make my views. I will not sit on that bench.
Okay.
Yeah.
All right.
So let me start, Commissioner, by first looking at the place of arbitration in our architecture of litigation. The place of finality of arbitral proceedings. The importance of parties choosing the manner in which they will resolve their disputes, and therefore party autonomy. I think we must not lose sight of those in interrogating this question as to what is delivery within the provisions of the Arbitration Act. Now, I may not have had the advantage of reflecting on this matter in the manner in which the critics have since done. I was coming from a place where the law appeared settled that in fact delivery meant notification of the award, and this was a line of decisions made by judges including Nyamu and Ransley. However, even after further reflection, I still think that there's an argument in respect to that could support my position, and let me try, Commissioner, to persuade you. Now, the parties choose that the manner in which they want to deal with their matter is through arbitration. They know the cost of arbitration. They know that there'll be a question as to whether the costs or fees of an arbitrator will have to be paid. They know the provisions in respect to where one party does not pay those fees, and its implication as to the ability for the arbitrator to release the award. The practice has been that once an arbitrator has prepared and an award is ready, is to notify the parties that the award is ready and to invite the parties to pay the arbitrator's fees. I am not aware of any provision that requires the arbitrator to, in fact, deliver physically the award itself, and so invites the parties to collect the award. In respect of this matter, I do recall that Senior Counsel Ngatia himself, who I think represented one of the parties, suggested that we should construe the word delivery from its meaning, I think in the Black's dictionary or something, which meant release or surrendering. So I took it that the question of delivery meant that the arbitrator had notified the parties that the award is ready and was then in a position to release the award to the parties, subject to the parties meeting the condition of paying the arbitrator's fees and costs. That might have been the basis of my decision, and upon further reflection, because when this matter came for certification, I had opportunity just to think over it. But obviously, there would be other views.
Okay.
I do not know, Senior Counsel, whether I have attempted to.
Okay. Judge, why it is important that, this is obviously subject to debate, and I truly respect your view.
Yes.
Is how can a party exercise their right to make a decision on whether to enforce, particularly the party that is affected, to challenge the award if they don't have a sight of a decision? Because then how would one make a meaningful decision, even with counsel, that they ought to challenge the award? That's number one. Number two is the practical effect is that this particular, because there is no, first of all, there is no single word about notification, I think, in the Arbitration Act.
Yes.
So
yes, there isn't.
There isn't.
Yes, there
it's not there.
Yes, it is.
So that the way you trace it, in fact, it's a decision that I think that was based on a 1959 English Act on arbitration that was delivered, that now was borrowed, that specifically spoke about notification. Mm-hmm. Then it was borrowed by Ransley, then it came to Nyamo, then it came to you, and you seem to have cemented it. And now what that means is now parties play games with arbitrators, and they push you to the end, the affected party, then you run out of time. So that by the fact that, an arbitrator either gives excessive fees or unreasonable fees or delays after notification, because time now starts to run after notification, not upon delivery. So a lot of parties are affected because they think by the time they make their choice about whether to exercise the right to enforce or to challenge, their time has run out.
Yes. I do appreciate that view. Now, I think let us not lose sight of the fact that the parties have chosen to subject themselves to arbitration. There are certain risks about taking risks and advantages of taking that route. One risk is that you'll be slapped with a big bill by the arbitrator. The second risk is that while one party is in a position to pay its share and willing to pay its share of the fees, the other party is unable or reluctant. Those exist even before the parties choose. And when the parties choose, to go the arbitration way, they make that choice willingly. Now, the effect will be that if one party has not paid its share of fees, it is upon the other party it would have been within their contemplation that the party the other side could be reluctant to pay fees, then to pay fees and collect the award within the time frames that are prescribed for making a challenge. Now, you must view this against the question of finality. Commissioner, just imagine where parties refuse to pay fees, and if the question of paying fees is the starting point for working out what is delivery, then they refuse to pay fees, the matter hangs on for 5 years, and then there is still the question of another party, the other party challenging the decision. What does that do to the question of finality of arbitral awards, and how would that reflect in our place as a country who sign up to that model of arbitration?
Thank you. Thank you, Chief Justice.
Thank you.
Thank you, Judge.
Attorney General.
My Lord, the Chief, another lawyer? there isn't a break.
Don't worry, have
Okay.
some water.
All right, thank you. Okay.
Sorry, Judge, I'll be very simple.
All right, thank you.
Now, I want to discuss with you the doctrine of proportionality.
Proportionality. Yes.
And I opine that the doctrine of proportionality, loosely described, is normally or traditionally has been applied in administrative law. And loosely it would mean the balance between the exercise of administrative power and protection of individual rights, or public interest, balance between public interest and protection of individual rights. Generally, the principle requires that when public authorities exercise their power, that exercise of discretion should be reasonable, should be fair, and proportionate to the end results that they seek to reach. Now, this doctrine of proportionality has become central in constitutional adjudication across Commonwealth countries and beyond Commonwealth countries. How should the Supreme Court apply the doctrine of proportionality or the principle of proportionality national security?
Thank you. Thank you, Honorable Attorney. Let me attempt. And you'll allow me to do so by setting out a personal experience in respect to this matter. Now, I was on the bench that dealt with the MRC issue in Mombasa, Pwani Sea, Kenya. The circumstances there, very briefly, was the question as to how the state can proscribe illegal outfit. The statute on proscription of illegal outfits set out the procedure in which the state could do so. We were then called to examine whether the state lawfully used that power. I think the starting point is to look at the article, I think 24, that deals with the limitation of fundamental rights. And so as to interrogate the action of the public body and as to whether it passes constitutional muster. So there will be the interests of the public body on behalf of the people of Kenya in respect to a national security issue, but which might
Did I hear you say public body?
Oh, state. You're talking about the state. Sorry, government. Is that? Sorry.
No, it's okay. I just wanted to be sure that I heard you say public body.
All right. I have in mind the government body, and so the manner in which one would interrogate this is, does the action taken or the statute enabling it, is it necessary for purposes of national security? Does that statute or action, is it the most or is it the least restrictive measure that can be taken? And maybe a third aspect is to look at it from the lenses as to whether there are other means of achieving the same purpose. Once those parameters are answered, then there'll be a question of then weighing whether the action that has been taken, in fact, is a legitimate restriction of a fundamental right. It's one that has to be weighed holistically. The parameters are set out in Article 24. The provision itself is not limiting. It sets out a list. The list can be longer, but one has to approach it from a holistic perspective.
But is there room for deferring security matters to the executive?
Oh yes, absolutely. And sorry if that skipped. For instance, in the matter of the MRC, which was endorsed by the Court of Appeal and has been cited by the Supreme Court, one of the questions that was placed before as a strong argument is that the executive had information about the criminal activities of the body in question. We found and held and were of the view that in respect to matters of national security, the executive must be given the margin of appreciation, their view of what is a national security breach or the possibility of national security breach must be respected. And so there is a manner in which there should be a balance. The decision itself in MRC was not about the correctness or the merit of the executive decision to proscribe. It was merely a question of the procedure that was followed.
Thank you. And finally,
okay.
Should the Supreme Court of Kenya see itself primarily as an error correction court, a precedent-setting constitutional court, or a guardian of the constitutional order?
So error correcting.
Precedent-setting constitutional court, or a guardian of the constitutional order?
Okay. So the Supreme Court has various mandates. In its appellate mandate, there are two parts, that of in respect to application and interpretation of the Constitution, and the other in respect to matters of general public importance. So there will be occasion in its appellate jurisdiction where the court will be called upon to interrogate the correctness of decisions that come before it. And in that aspect, it might be viewed as an error-correcting court. There'll be times when it must seize opportunity that are presented by disputes that come before it, in respect to moments that are presented of jurisprudential significance, when it will set out precedent that unsettle important areas of the law, which will give guidance to all the other courts. Should the Supreme Court be a guardian of the Constitution? I think it should. I think it should, just like all the other courts right from the subordinate courts, because the command of the Constitution is that in exercising judicial authority, we must be guided by the Constitution, we must give it its full purpose, we must give it its full effect. So it must be a guardian of the Constitution, and I think the many decisions made by the Supreme Court tell of this important mandate or speak to it.
Okay. Sorry, CJ, I said final, but since I've saved a few minutes, may I ask a final question?
Okay.
Sorry, but may I ask just one more question?
Yes, absolutely.
Now, the Constitution of Kenya is transformative in character. Do you agree?
Yes, I do.
Now, do you consider that it has an implicit basic structure that is beyond amendment? And I am cognizant of the fact that the issue of basic structure had been discussed in this forum while we were interviewing an advocate some time ago. However, is there a provision of the Constitution that is beyond amendment? And if so, what constitutes that structure? And how should the Supreme Court approach a constitutional amendment that arguably would alter that structure if it is there?
Mm-hmm. Thank you, Attorney General. I mean, somewhat an embarrassing situation in respect to that matter, because the question was posed in the BBI dispute, and the question was the place of the basic structure in our amendment vis-a-vis the amendment provisions of the Constitution. The view that I took with the majority of the judges at the Court of Appeal was that, yes, the basic structure doctrine applied to Kenya, and so introduced a fourth tier test to amendment. The matter was escalated to the Supreme Court. I have read the decision of the eminent judges of that court. I now have no doubt about the correctness of that position. I've had time to reflect. The debate may go on. I think, and reading, my lady, if I recall, your decision is that you posed the question whether the fourth tier, I don't know that the cockroach has anything to do with the question. Sorry, the fourth tier test was in fact introduced through judicial craft. So yes, all provisions in the Constitution can be amended. Some which are foundational have been given stronger guardrails, and it's more difficult. The process is very exciting and would guard against the willy-nilly amendment of those provisions. We had, on reflection on the arguments that were set out before us, thought that, in fact, we could tighten those amendment provisions beyond the provisions of the Constitution by a fallback to the basic structure doctrine.
So what is the sum total of what we are saying? Is there a provision in the Constitution that is beyond amendment?
No, all of them are amendable. Some are the foundational ones. Nevertheless, the process is more involved, in fact extremely involved, so that amendment is not easy at all.
Thank you.
Thank you very much.
Thank you. Justice Murima.
Thank you, Honorable Chief Justice and Judge, once again, welcome.
Asante.
You may take some water, Judge.
Oh,
Please.
thank you.
Okay. I want us to revisit a discussion which you've had earlier on the issue of locus standi. And we focus on Articles 22 and Articles 258. If you look at Article 22, 22.1, of course, it deals with the enforcement of the Bill of Rights. And this one is in respect of rights and fundamental freedoms to a person. Every person has the right to institute court proceedings claiming that a right of fundamental freedom in the Bill of Rights has been denied, violated, or infringed, relating to rights to a person. You can file proceedings in court claiming that these rights to a person are being violated or are being violated or are threatened with infringement. Now, when you go down that provision, it now addresses further the issue of locus standi. And you've been taken through the locus standi issue on A-B, but I want us to go further to C. C states a person acting in public interest. What does that mean? It means even when you are dealing with rights and freedoms of a particular person, still proceedings can be initiated in public interest. We are together to that?
Yes, yes.
Good. Then let's jump to 258.
258.
Yes, 258. Article 258. Article 258 deals with enforcement of the Constitution. 22 deals with enforcement of the Bill of Rights, the rights pertinent to person. 258 deals with enforcement of the entire Constitution. And again, in Subarticle 2C, it gives right to every person to institute court proceedings claiming that the Constitution has been infringed or contravened or it is threatened with contravention. And again, under C, it gives a right to a person to institute these proceedings in public interest. So public interest cuts across.
Yes.
It doesn't matter whether you are dealing with a fundamental right to a person or you are dealing with any other aspect of the Constitution.
Yes.
That locus standi in respect of public interest cuts across. Now, with that background, Judge, we have seen an increase of public interest litigations. And of course, that's to enhance access to justice and of course the need to protect the rights, freedoms, and of course the Constitution. But there has been a trend where some public interest litigations have been either dismissed or struck out or denied on the basis that these public interest litigations are not PIL per se, but they are disguised PILs. Now, if you look at the background we've gone through, that public interest cuts across, whether it is Bill of Rights or or whether it is the Constitution itself. Do you think you can clearly draw a line between personal and public interests in looking at 22 and 258, the articles of the Constitution? Do you think you can really say that this is the line dividing this is the line, dividing PILs from the other matters in respect to public on the account of public interest?
Okay. Thank you, my lord.
Or in other words, Judge, yes, how should a court, what considerations should a court put in place to come to a conclusion that this matter is a disguised PIL?
Okay, thank you. The first is by looking at the pleadings, by interrogating the pleadings, and so as to answer the question, is the matter before me one that even merely on the reading of the pleadings reveals a truly public interest concern? The other, and which is tied to that, would be to look at the nature of reliefs that are sought. There has been judicial decisions that have discussed what is a public interest. Is it a matter that involves the welfare of a large segment of the population? Is it a matter that involves, say, the people of Kenya? Just to look at whether the pleadings and the prayers align with the position of the law in respect to what is public interest. I must say this, however, that pleadings may not tell the entire story. The evidence could reveal what is hidden in the pleadings. The evidence, on the other hand, might clarify what appears to have been misrepresented in the pleadings, so that the evidence shows that it is a truly public interest matter.
Judge, if we can hold it at that.
Yes.
With that explanation, do you therefore think that the locus given to persons in 22 2C, when you're dealing with Bill of Rights, the locus given to people to act in public interest is more or less like misplaced in this Constitution?
No, I don't think so. And sorry, I was concentrating on the 258.
Okay.
I was concentrating on the 258.
Maybe you also touch on this one.
Yes.
Because I think public interest is the same here.
Okay.
Both 22 and 258.
Okay.
Yes.
So I was just going to say that in respect to the question that you asked, whether there's a firm red line that can be drawn.
Yes.
It may be difficult. As a judge, I might be reluctant to dismiss a matter of that nature as a preliminary point, because there might be questions of fact that are contested, and those that might reveal the true nature of the litigation. No doubt, nevertheless, Judge, Commissioner, I agree with you that public interest litigation can be abused to advance a private agenda?
We may have to initiate further discussions
Yes.
on this aspect, because if the law recognizes the issue of public interest in the Bill of Rights as well as in 258, then to me, there's no borderline. It cuts across, because public interest is everything. So for a court to come and say that this matter is a disguised PLA, is it disregarding the Article 22, only concentrating on 258, or I think it's an area which needs further interrogation.
Yes. Judge, if you may just allow me to say this.
Yes.
In respect to Article 22, you are very kind to set it out.
Yes.
That is in respect to fundamental rights,
Yes.
where fundamental rights. And in those instances, it might be easier for the petitioner to prove that, in fact, it is a truly public interest matter. But in respect to 258, which is generally all the other provisions of the Constitution, that line may be a little more blurred. I say this cognizant, for instance, that the provisions say of the Constitution also provide in respect to public procurement, and so there could be questions where there are surrogate litigants who are arguing a personal agenda but making it look like a general public interest matter. But I know there's a difficult, and I do acknowledge.
Okay. Now, having appreciated the fact that there is a challenge, there's some difficulty, do you think there should be a legislation on PILs?
There should be
a legislation on PILs, public interest litigations?
Thank you, Commissioner. I think there's a rich body of decisions right from the Constitutional Court, the Court of Appeal, and the Supreme Court that point out the nature of controversies and the debate around public interest litigation. My view, nevertheless, is that to leave it to legislation might, in fact, embed the fear that you have, my Lord, that it would then be even further restricting the provisions in respect to public interest litigation, which might be a clawback to the spirit of the Constitution. So I wouldn't myself think that legislating it and beaconing it through legislative framework would be helpful.
Okay, and lastly, Judge, let's have a look at election reforms. And in your introductory remarks, I heard you confirming that you're a member of GCE. And since the first general election post 2010, the current constitution, and the resultant election petitions running from the Supreme Court to the magistracy, courts have been struggling with the issue of technology and the manner in which elections are generally conducted in Kenya. By now, Judge, what reforms do you expect IEBC to have put in place or to put in place on the use of technology in elections in readiness of the next general elections?
Okay, thank you. The starting point is to see the place of technology and leveraging technology in respect to electoral processes that is acknowledged by the articles of the Constitution. It has been the history of the election petitions, and particularly I think the 2017 one and the latest, discussed the place of technology as an enabler of a free and fair, efficient, verifiable election process. The 2017 petition, which the Supreme Court had the opportunity of determining, there were certain recommendations in respect to technology, which I think have been implemented over time. In respect to the reforms, it is acknowledged that technology evolves. It is acknowledged that sometimes it fails, but it has an important place. The legislation that is available there provides a general framework which anticipates the ever-evolving nature of technology. Again, I do not know whether election reforms should be prescriptive of questions of technology, acknowledging that the technology used today will be outdated tomorrow. That would be my tentative view.
So Judge, like going by what has been happening in Kenya, what do you expect to see in the next general elections in terms of some of the reforms, like issues which came up last time, that the server, some server is held somewhere, where in Kenya is day and that place is night. What is your thought on some of those things?
I think the question as to the server, its integrity, whether it could be accessed, all came within the debate as to the credibility or the use of that technology. But one of the provisions in the Elections Act is the use of transmission of the results from the polling stations and the use of technology in that process. There is then the question of identification of voters using currently the KIMS kit, and an acknowledgement that technology may fail, and so there can be a fallback to the manual processes. What I would expect to see in the upcoming elections perhaps is a deeper an explanation as to the technology that is used, so that the public is aware of the nature of technology and how it works. The technology, I think when you talk about transparency of an election, because election is a process, includes transparency in terms of explaining the technologies that will be deployed in carrying out the election. I say this because there are two schools of thought as to whether in fact there's a question of a server that has a certain hidden information and which you can look into to find instances of hacking and so forth. So there might be information gap that IEBC may need to address, and which is mandated by the Constitution to carry out.
Okay, Judge, I think we can rest it at that, with the hope that all said and done, at least every equipment used in the elections should be within the borders of this country, so that to enhance transparency, so that and accountability, so that if anybody wants to carry out an audit on a server, the server should be available. These are some of the things we expect IBC to bring on board. I wish you the best, Honorable Judge. Thank you, that's all.
Thank you. We now move on to Commissioner Ngutia.
Good morning, Commissioner.
I'm happy.
Okay.
Okay, you're well? You need
Yes,
some time to take water? Or?
No, I'm well, thank you.
Welcome again. So, Judge, you did submit to us decisions you have handled at the Court of Appeal and those that you also handled when you were at the High Court, and they touched on the Court of Appeal. You have the BBI matter, the land that was created after recession of Indian Ocean, and enforceability of dispute resolution decisions. At the High Court, when you were at the High Court, you shared your decisions on matrimonial property and a commercial dispute. And when the Chief Justice asked you to share some of the decisions that you have made that have contributed to the growth of jurisprudence, you told her you don't want to blow your own trumpet. And for me, I go with Chinua Achebe's words that the lizard that jumped off the high Iroko tree to the ground said he will praise himself if no one else did. So I always believed I should praise myself as I wait for others to blow my trumpet. So allow me to blow your trumpet the other way.
That's very kind of you.
So in the BBI matter, yes, you did contribute to the growth of jurisprudence among the sample writings you shared. And what I also liked about it is that the bench, you wrote your own separate decisions. I hope it's a practice you can take to the Supreme Court, not for all matters, but at least a few of them. So I also took note that the Supreme Court adopted most of your findings, save for some which my sister commissioner and Judge Sichale dissented, but the Supreme Court affirmed her decision. And then the timeless property limited, again the issue of what happens to land created after rescission of land in the Indian Ocean. You also held that the title cannot stand because the creation and alienation was legally defective. So again, that's a good decision from your bench. The National Irrigation Authority, again your sample writing. The court reinforced the pay now, argue later principle. And if parties had accepted to opt for the dispute, resolution of the dispute through the dispute board and not arbitration under the FIDIC pink rule, they could not go back. Again, I commend you for that. And then lastly, you did share with the Chief Justice the division of matrimonial property. You handled it when you were a High Court judge, and you affirmed equal contribution must include both financial and non-financial contribution, such as domestic work. And here you did elevate the place of non-monetary contribution. And allow me to just read part of your decision. I take the view that at the dissolution of marriage, either partner should walk away with what he or she deserves. What one deserves must be arrived at by considering her or his respective contribution, whether it be monetary or non-monetary. The bigger the contribution, the bigger the entitlement. Whether there is evidence that a non-monetary contribution entitles a spouse to half of the marital property, then court should give effect to it. So I think I agree with your finding there. And in that same decision, you further affirmed that the principle of equality is applicable even for property that were acquired before the 2010 Constitution. So I commend you for that, Judge. I have 3 questions for you, but not too, don't be scared. So in the BBI case, at the Court of Appeal, your position was that the basic structure doctrine was applicable, and we know that the Supreme Court did not agree with you on that, but affirmed, as I said earlier, affirmed certain things that
you had mentioned in the Court of Appeal. So other than the issue of basic structure, we've seen the Supreme Court accepting practices from other jurisdictions, the issue of structural interdicts and the issue of suspension of invalidity of a law, which are borrowed from other jurisdictions. I know the facts with the three cases are different, but my question is just around the issue of indigenous jurisdiction. If you look at Section 3C of the Supreme Court Act, the Supreme Court is required to develop rich indigenous jurisprudence. So it's expected to learn from other jurisdictions, but contextualize the issues without blind adherence to foreign precedent. So if appointed as a judge of this court, how would you balance the value of comparative constitutional law, doing from other jurisdictions, and with the need of developing homegrown or indigenous Kenyan jurisprudence? That's question number one. And under what circumstances would you decline to follow a persuasive foreign precedent, and what criteria would you employ to determine that a particular foreign doctrine is incompatible within the Kenyan constitutional space, including history and structure? That's it, those two questions. Right. Sorry, it's a mouthful, but I think you get there. I needed to bring the context.
Thank you. You'll forgive me if I seek clarification in respect to the second.
No worries.
Yes. Let me attempt to demonstrate by what we mean by rich indigenous jurisprudence. I think indigenous jurisprudence will be one that is takes into account the context of the Kenyan people, its history, its current place, issues of the culture of the people, and the text of the Constitution itself. And I know that although this is controversial, it just might help to demonstrate what I believe is an indigenous, one of the cases that reveal indigenous jurisprudence. The Dina management case, the famous case in Dina management, which has attracted substantial controversy, acknowledges that in the history of this country, there was a time that public trust was abused, and there was illegal allocation of public land, which was perverse. This issue may not be an issue in other jurisdictions. It would in fact be unthinkable in certain places. But in applying the law, the provisions of the law, the Dina management case, addressing the peculiar and unique circumstances of our country, departed or in a manner challenged the correctness of the torrent system as applicable in our country. So yes, what we refer as indigenous jurisprudence is one that reflects the realities of the Kenyan people. It might surprise lawyers in the common law, say in the UK, that we could be moving away from the torrent system. There's be a debate as to how much of that we should do, but that reflects the tension between the attempt to protect public property and the manner in which those who desire to own land must be a little more vigilant, or a lot more vigilant, in respect to interrogating the history and the root of title. So that is one example that I gave. I hope I've answered that
Yes.
part of the question. Sorry, if you could perhaps go to the second, it might help to the second part.
So how would you balance borrowing?
Okay.
Yes, the
All
two.
right. Now,
And, at what point would you decline from using persuasive foreign precedents?
yes. One of the places to start is to read a foreign decision alive to the facts that the court or that decision intends to resolve. One must also be fully aware of the statute and the legislation that the court is asked to interpret, the foreign court. If it is parallel or reflective or a mirror of our constitution or our legislation, then there could be value in applying the reasoning in terms of resolving a matter that would be before us. I say this nevertheless that I think, and this is in my interaction with judges from other parts of the country, the Kenyan courts should take its pride of place. We are recognized as a very progressive judiciary with rich jurisprudence and one that reveals amongst the judges and judicial officers intellectual rigor. I suspect that it is from that perspective that a lot of decisions I read from the Supreme Court, in fact, make a lot of reference to our own laws. There have been occasions when the Supreme Court has drawn from the wisdom and extremely well-reasoned decisions from the High Court. Very often, I think, you will find greater value and persuasion from our own judges than looking outside. I think in the same breath, if you ask other judges outside the country whether they should draw from persuasion from our courts, they will happily be able to do that. So we should be more proud, more inward looking, and the Supreme Court has really given us the path. Thank you.
Okay, thank you, Judge. And I do agree with you that the dinner management matter actually tells the story of the land question we've had over the years in our country. My second question is that the advisory opinion number 2 of 2012, the one on two-third gender principle. So the Supreme Court held that it should be progressively realized by majority, and the then Chief Justice Mutunga dissented, arguing that that political right required immediate implementation. It's over a decade and we are yet to get there as a country. In hindsight, do you believe that the 2012 advisory opinion was correct? Would you have done it differently if you sat there? And how would you distinguish rights that should be progressively realized and those that require immediate enforcement?
Okay. Thank you. That advisory opinion is one that reveals a very difficult matter. The decision, and I agree with it, that the two-thirds agenda needs to be implemented. I would think that the majority, time has revealed that the majority may have been right because of the extreme difficulties in implementing the two-third agenda gender in our political or elective positions. There's been debate. I have been in rooms where certain solutions have been given or attempted solutions have been given. Many of those solutions will in fact require amendment to the Constitution. Even with amendment to the Constitution, I'm not too sure that it will still be sufficiently addressed. And I say that there might have been wisdom in the majority decision because the debate, some is insincere, but very often others are sincere, reveals the practical difficulties of implementing the two-third agenda, gender parity in elective positions. I would hope that this matter will still find some solution. It might require a constitutional reform at the right time when the people of Kenya will have the faith that it is time to relook at certain aspects of the Constitution. But what the advisory opinion does, very importantly, is to set out a debate that the Kenyan people themselves must resolve in whichever manner, either through legislative or constitutional reform. Moving on to your second question, the issue of framing a remedy to a constitutional issue, giving a chance for progressive implementation, is one of those that the country has embraced. There might be, and I give an example of the Me Too Bell case, where the court pronounced itself very clearly that the question of the socio-economic rights is not just aspirational. Those are real rights that can be justiciable. But it cannot be lost on us, and the Constitution was alive to this, that certain implementation may require legislative reform that needs to be put in place. Others may require resources to be arranged. They will require money, say, to build houses, to acquire land for the landless. Others will require policy decisions by the executive arm of the government. So in fashioning a remedy in a matter that is before me, I would be sensitive and aware as to whether its implementation has certain implications in respect to resource mobilization, legislative and reform, and policy reforms that would involve other arms of government. That is how I'd look at it. Nevertheless, where it involves other fundamental rights that we require immediate implementation, I have not been shy to do that in the past, and I would do it again.
Okay. So there's an argument still on that civil and political rights require immediate realization, yet economic, social, and cultural rights require progressive realization. Yes. Are you in agreement with that, or it depends?
You said political?
Civil and political rights require immediate realization, whereas economic, social, and cultural rights require progressive realization. There's been that argument.
Okay. I'm not too certain. I've understood it, but let me just try. Let me try to address that. If you're talking about political rights, say the right to vote, the right to participate in a political party of your own choice as a citizen, there might be no difficulty in terms of declaring that they need to be immediately implemented. In fact, giving a remedy that suspends the enjoyment of such a right would be an antithesis of the spirit of the Constitution, the letter, in fact, of the Constitution, not just the spirit.
Okay,
Yeah.
thank you. Lastly, Judge, as a Supreme Court, if appointed as a Supreme Court judge, you, even right now, I know you're still a member of the legal profession.
Yes.
But as a Supreme Court judge, by virtue of your office, you will shape the culture within the legal profession. So how would a Supreme Court judge promote integrity and professional ethics within the profession? And number two, promote cross and intergenerational learning.
Let me start with the last one. The Supreme Court is at the apex of the ladder in the judicial structure of the country. It is a court that, and I think it has lived to this, one that sets or should set the gold standard of practice in terms of pleadings, in terms of court appearance, in terms of hearings. The virtual court, the online court, has somewhat stifled the avenues of learning for the younger generation. I've always wondered whether the Supreme Court, and if I was a member or included as a member of that court, would be suggesting that in fact some of its hearings that is designated at certain times should be physical, inviting members of the profession to have a real life experience of a court that operates at that level and with such excellence. I do not know whether going forward there'll be opportunity, in fact, for the court to circuit the country occasionally so that there is a feel of that court in Nyanza, there's a feel of that court in Garissa, and the learning impact that it may have on the younger professions in those parts of the country. So yes, I think there is an opportunity there, and I'm aware that even the Supreme Court now has set up programs in that respect. What would be my role as a judge of the Supreme Court in terms of shaping up questions of integrity? I thrive to do this even as a judge now, and when I was at the High Court, to conduct myself in uttermost integrity, to demonstrate through my decisions that I am impartial, to be open to scrutiny. I know that there is a question that we routinely, as judges or public officers, are supposed to open ourselves to scrutiny in terms of our assets and liabilities. We fill these forms regularly, on a regular basis. One of the ways I think in which integrity of the judiciary can be enhanced is if each one of us as judges are able to explain our wealth without fear, openly. Other ways of conducting ourselves is to be accountable for what we do both in public and private lives.
Okay, thank you, Judge. And the bar from where I practice from asked me to wish you the very best and thank you for the service you accorded them and your bench when you're there. I wish you all the best.
Thank you very much.
Thank you, Justice Njoki.
Yes, it's It's still good morning, Judge.
Oh, good morning.
And the lawyer questions are still continuing.
Yes.
I empathize with you as well.
Okay.
But we are going to move fairly fast. Let me just do a couple of follow-up questions, which you were asked earlier, just to get some clarity. Commissioner Judge Sichale, while asking you about the question of locus standi, and then we asked you a number of other questions around it, had asked whether you think the Supreme Court has restricted access to justice with regard to interested parties, and particularly she mentioned Forgicha. I wanted to know your understanding of the Forgicha matter in that context.
Okay. Thank you. I think this litigation started off before Justice Macau in respect to the dress code allowed the hijab by the Muslim faith. And initially it was between the petitioner. I do not recall whether it was one or two petitioners. But because of the importance of the issues that arose, others joined in as interested parties. I think to urge that the decision would not only affect the petitioner, but would affect others as well. So, in my view, the courts in allowing interested parties or an interested party was alive to the fact or the weight of the matter that was before it. The matter progressed to the Supreme Court. If indeed it is a question of locus and whether the interested parties should have been given a greater say outside the pleadings or the case that was pleaded by the petitioner, I would have wondered why opportunity had not been taken early enough by the interested parties to mainstream themselves as parties so as to argue their matters, either by taking up other petitions which would then perhaps be consolidated, and that is why, my lady, it seems clear to me that the decision reached by the Supreme Court in that respect does not constrict or limit the place of interested parties and locus in that respect.
Thank you very much. You also had asked Commissioner Mwanza a question as to whether there was a correctness to your answer on experts. So let me confirm.
Yes.
It was correct. And the Supreme Court can and has used experts.
Okay.
But we do so very rarely.
Okay.
But you are correct, we have done it. Coming back to the issue of FGM and consent, I was trying to understand your approach. Are you suggesting that if you're an adult and you understand that cutting off a part of your body is harmful, is it still all right? Would we use the same principle for cutting off one's arm or for committing suicide? Is it okay? I want to, so I'll do it. Even though you're an adult, I wanted to just understand, or whether I didn't understand you correctly.
Okay. My question of consent was in respect to whether it was voluntary consent. There is, of course, the other aspect of consent vis-a-vis whether you can consent to certain things within the constitutional framework. For instance, in respect to the right to life, stating and the illustration that you give regarding suicide, I think that would be expressly repugnant to the values that we hold and that are in the Constitution. And the question of whether you can readily accede to the cutting off of your hand would fall in that category. I suspect, at least from my own belief, that the mutilation involved in FGM is similar.
Thank you very much. Let me come then to my own questions. Often the Supreme Court finds, as a top court, it's a political court, that we are called upon to resolve questions which are amongst or in between government institutions, and sometimes we are confronted to whether we ought to apply the political question doctrine or whether to apply judicial restraint. What would your approach be in the balance that is to be reached between the two? Is it a political question to be resolved by institutions that are political? Is this a question that can be resolved by judges? Okay. And therefore we should restrain ourselves? What is the balance that is to be achieved?
Okay, thank you. I think there are a number of cases that the Supreme Court has had to deal with that have demonstrated the tension that you've just alluded to. The question, for instance, that the court had to deal with in respect to the money bill or the Finance Act. The Finance Act. The court would have to be cautious where questions lie purely within the sphere of executive power, which are policy oriented. The court would have to be cautious and circumspect, knowing or alive to the fact that the role of the court is, one, to identify whether the matter is in fact justiciable, and should it pass that first hurdle, to then address whether the conduct of legislature or the executive infringes or violates the provisions of the Constitution. So it would be in a very narrow aspect in terms of testing the decision of the executive or the legislature as to whether, in fact, it passes constitutional muster. Another decision that may demonstrate this is the Sonko matter. I do not know whether, Judge, you dissented on the matter, but I am aware that there was first a question as to whether the matter passed the jurisdictional hurdle, but in terms of the decision that was pronounced by the court eventually, it was cognizant that in terms of impeachment matters, it is a political question, and so for as long as the impeaching bodies, the bodies with a mandate to impeach, follow the procedures set out, if the charges that are laid before the officer to be impeached are those that are set out in the Constitution and where they are found within the framework of the charges set out in the legislature, then it is not for the judiciary to second-guess the merit of the bodies who are given that mandate. So the question of merit is one that should be avoided in my view.
Okay. In the court also, we find ourselves frequently challenged, and I think many courts also, of the superior courts, you can have a matter before you where, as a judge, you can see there is a legally correct outcome, but that outcome will end in injustice. How should a judge be guided in those kind of circumstances?
Yes, okay, thank you. I think the judges who are in this room will no doubt have been confronted with this matter where you can see that your interpretation of the law and the facts before you seem to lead you to an outcome that otherwise looks unjust. The manner I would go about addressing that is, once I'm confronted with that struggle, is to be sure that in fact my interpretation of the facts and the law are correct, so that in the end, if I reach the decision that appears to be unjust, it's one that I can live with. And allow me to just give you an example. When I was appointed a judge, we appointed 28 of us. I went to Mombasa, and many of the matters that we were to deal with were in respect to sexual offenses, defilement. You would be confronted with cases where you think that if the investigation had been properly conducted, a conviction should be, we should return a conviction on appeal, and those matters would disturb the judges. In fact, we used to call one, I would call Judge Chemete would call me, I would call other judges, because it's disturbing to see a child of 9 defiled. It appears that truly that may have happened. The investigation was botched. But in the end, in resolving that struggle, once I was sure that the law and the facts could not reach any other result but that supposed or apparent unjust outcome, then I would give it up. And that would be the end of the struggle. And I would implement the law, notwithstanding the injustice that it leads to. Then there would be other instances where, for instance, for example, the outcome may be unjust, but which you can mitigate with by fashioning remedies that ameliorate the handicap of the party who has to or who is visited with that injustice. Those are two ways I would approach it. The third would be to speak very clearly in respect to the injustice that I see that my outcome has reached, or my interpretation. I would reflect upon it. I would want to be understood that notwithstanding an outcome that can be viewed as unjust, I have sufficiently explained myself on the path and how I have reached there. Where, for instance, I think they need to be policy intervention or legislative reform, I would pronounce myself and leave it to the bodies left or with that remit to do their bit.
Thank you. The judiciary has developed extensive electoral jurisprudence. And I'm just wondering whether you can give us examples of how courts have made it easier for dispute resolution, and whether or not there are challenges around the way that election disputes are resolved, how can we improve the way courts do it, given that the time frames are limited? What can you share with us?
Okay, thank you. Let me address this, taking the position that I occupy. I am a judge of the Supreme Court, and so I would be anxious that the timelines given by the Constitution for resolving a presidential election dispute are extremely tight. The rules of the Supreme Court in respect to the presidential election disputes, I think, are set out certain processes that make it easier, some sort of toolbook to allow the judges and that court to deal with the extremely tight timelines. For instance, after the filing of the petition, service ought to be on the same day in soft, online. Physical service of the petition and the respondents has to be within 24 hours. The response must be then within 4 days. The timelines are tight, and somewhat is an attempt to balance giving sufficient opportunity to the parties to make their cases, yet giving some space for the court to hear and determine the matter in a way that they can sufficiently interrogate the dispute. Then there would be, and what I thought was an ingenious manner of dealing with interlocutory applications. The filing of interlocutory applications and the end of the process where alongside the final responses, they be dealt with at case management level, the decisions be granted if it is peremptory, reasons can be granted late, can be given alongside the main decision. The other manner, I think, that has enabled the court to carry out its mandate within the tight timelines is to give a decision and then the reasons later. I have known that in certain jurisdictions the reasons can come 6 months, 7 months, 8 months later, but the decision, the time the Supreme Court has set on itself and the rules that the decisions must be, I think, within 30 days. So there is no anxiety on the parties to know the reasons, yet it gives sufficient time for the judges to explain themselves fully on what is often very contested and extreme public interest issue matter. So I can see that the rules over time, that the rules that have been put in place can assist the court in dealing with those time frames.
Thank you very much. So you see, it's very tight, the time frames.
Yes.
And therefore, you can imagine when we are listening to a presidential election petition, we are hardly sleeping, and we are working throughout. Do you think that you have the, not only the courage, but the character to manage to work under such intense pressure, lack of sleep, working with documents coming in, doing rulings overnight? Do you think that you, in your experience, this job that you have applied for, in those circumstances, that you have the character to manage under such high pressure?
Thank you. In applying for this position, I am acutely aware that the question of presidential elections is a cyclical affair. It invariably happens every 5 years, and I've watched the workload that the judges must deal with, and I'm obviously sympathetic. Nevertheless, I think in my the courts, the other courts which have been called upon to deal with election petitions are also under certain strict timelines. The resolving quickly interlocutory matters. In my experience at both at the High Court and the Court of Appeal, I've had to deal with those matters. I have not had any difficulty at all. I think I have the endurance and to carry out the job, notwithstanding the difficulties that the timelines portend. In doing so, I have thought of efficient ways in dealing with timelines, is to be overly prepared, make use of research assistance where it is available, to prepare myself even mentally of the task that will be ahead of me. I believe that I would have no difficulty at all.
Thank you. You have been in a collegial court. You are in a collegial court. How do you manage when you're dealing with difficult matters, when you need to discuss? You had a dissent in the BBI, so obviously you're not able to persuade your colleagues on one or two issues. But what are the necessary elements of collegiality when discussing hard cases?
When you sit in collegial court or a multi-member bench, you realize that members of the bench, the very divergent opinions people would have on or take in matters. Sometimes when it's a difficult matter, there would be areas where there is deep disagreement on legal positions. Yet that should not, because of the divergent and because you disagree with the position taken by your colleague, that should affect the manner in which you relate. One should be open to persuasion. The manner in which you look at a matter now may change, and you must have a listening ear. You must have an open mind. Where you eventually disagree with a position and you hold that you must express yourself, then you do so. You must do so respectfully. Your decision should not be a critique of your colleague's decision. You must be measured in your language. You must be respectful. And in fact, where you have to render a separate decision, you might have to explain yourself where you are departing from members of your court. The question as to whether there is a difficult question should be one that the judges sitting in that bench should take as a collective challenge, which they must, in a collaborative manner, deal with. And that calls for tolerance, and it calls for flexibility. Yet, at the end of it, if you must disagree, then you must do so respectfully and in a manner that endears to the principle of collegiality.
Thank you. One final question. In the Supreme Court, we have suffered from the perennial problem of quorum challenges, because the quorum of the court is 5, the number of the judges is 7. What advice? How would we resolve this problem that has been with us from the beginning of from the start of the court?
The question of quorum and
the challenges of quorum.
Yes. The number of judges that make up the Supreme Court is static, and it is within the Constitution. The quorum is 5. There will be times when a judge appears to be conflicted in a matter and unwilling to, or would otherwise be reluctant to hear and determine a matter. Yet, cognizant that of the small number of judges, questions of recusal of judges, questions of whether on application or that judges would otherwise make on their own motion requires to be done with a lot of caution. I am aware that the court has, in its jurisprudence, discussed this matter and have come out with the principle of the duty of a judge to sit. I think this was in the case, one of the Rai cases, the duty of a judge to sit. So, aware that of the few numbers, the court in addressing the questions of recusal must not approach it like any other courts would. And I think this jurisprudence that has been churned out sufficiently deals with it.
Thank you very much, Judge CJ, and I am done. Thank you.
Thank you. Thank you very much. We now move on to Commissioner Rwande.
Thank you, Chair. Good morning once again, Judge.
Good afternoon.
It is now afternoon,
yes.
Sorry. Good afternoon. We finally get to move to the less technical and a lot easier segment of your interview. Yes, I have a performance report here from DISPO. And I hasten to add that I'm having a bit of challenges, and I'm sure you're familiar with the challenges we may be facing, especially evaluating the performance of a collegiate bench. But I'll just give a summary of, because it's quite lengthy, and in the interest of time, I don't want to tire you with the many details. I'll just give a summary of what they have mined out of the work that you have done, and explain the approach I've taken in sort of analyzing it, and then you can tell me what you think about it and also the challenges that you see. So essentially what has been done here is that the work you have done, the benches that you have sat in various courts, the output in terms of merit resolutions has been compared to the output of the entire court. So they've taken into account the number of benches you've sat in over a period of 3 years, the merit resolutions vis-a-vis compared to the merit resolutions of those courts where you sat. So in total, I see you have sat in 14 benches. Yes, that's what I have, 14 benches. And out of the 14 benches, the merit resolutions, it's only in 3 benches. No, let me say 3 occasions, not 3 benches, but 3 occasions, when the output compared to the total output of the particular court is higher than 30%. I don't know if you understand. That is now my own analysis. Yes, it's higher than 30%. So that 3 out of 14 times, your contribution to the total output of the station has been over 30%. The rest have been below. Now, I've already expressed the challenges that are there in evaluating the performance. The one that is so obvious, the performance of an individual judge, quite obvious. But then now as a bench, maybe you can share with us, if, because you are the wearer of the shoe and you understand the dynamics, whether that is a safe approach. And if you want to comment on the report I have just shared, you can also do that.
Okay, thank you. That report was shared with us a few days ago. I looked at it. I was surprised by the story it attempted to tell. Now, I would invite you, Commissioner, to look at by output when sitting in Kisumu. And I do so because of something I want to explain. When I was posted to Kisumu, we were 3 judges at any one time. And so we sat together as 3 judges all the time. It is then easy to judge the performance of that bench because it is constantly and ever manned by the 3 judges sitting together, other than on occasion when one is on leave or for any other reason away. Now, it will shock you that I have sat on 14 benches. I mean, this is when I moved to Nairobi, where we don't have fixed benches. Secondly, where I have had to be on relieving duties, either in Mombasa, Malindi, or elsewhere. So the statistics that you see are not unique to me as a judge, would not be unique to me, but would be reflective of the somewhat distorted picture that it gives when a judge finds himself sitting today with Judge A, then tomorrow with B, where the benches are not constant. What, in my respectful opinion, is that there might have to be remodeling of the manner in which the outputs in where judges don't sit constantly as fixed benches will need to be fashioned.
What are the suggestions you'd make, for instance? In what way? Fashioned in what way?
I think there would have to be a discussion first with the members of the Court of Appeal whether the benches don't need to be fixed. But if, in the end, if that cannot, for some reason, be feasible, no suggestion comes to mind. No suggestion comes to mind because it is very difficult to judge the individual outcome of judges sitting in a multiple bench. But that might, I do not know whether that it will be open for that to happen by looking at the individual output and what that does to a collegiate court, the implications it has. It's not an easy conversation to have, and I think it will require the output of the entire court and other stakeholders.
I appreciate that, and that's why I gave the disclaimer earlier that when it comes to the individual performance, that is not an area so far we can venture, and that's why the performance we are looking at is the performance of benches. You mentioned the Kisumu, the period you served in Kisumu. I have the statistics of Kisumu as well. you were 3 judges permanently, or did you have occasion to have different benches where you did not sit in?
Occasion.
There were some benches that
Yes,
you did
yes,
not sit in?
when one member would be on leave.
Yes.
But a substantial time sitting together, the 3 of us. Yes.
Okay, that is what I was explaining earlier when I said the output of the benches when you specifically sat was now being compared to the output of the court itself, including the occasions when you did not sit. But as you say, it's a bit difficult, and I think that's the other bit of the conversation we can have on another date, but that is what I have, and I appreciate the challenges. So the other question I wanted to ask Judge concerns performance in general. The carrot and stick approach is very common in most jurisdictions. I was just reading somewhere about a very interesting scenario in the Spanish judiciary. Apparently, in the Spanish judiciary, when it comes to performance, their carrot and stick approach is such that it actually affects your salary. So that you have a bit of your pay, your remuneration, as fixed, and then there's a bit that is pegged on your performance. You sort of earn a bonus. So that if you meet 100% of your target, then you get a bonus of 3% of your pay. If you exceed by about 20%, you get 5%. And of course, if you go below 80% of the target, you suffer until recently, you suffer a 5% cut. That is in the Spanish judiciary. Also in the US, there's a sanction in the fact that your performance results for all judges are made public. And you know, in some courts, they get elected to those positions so that it is possible that once your performance has been displayed out there, you may not get re-elected back to the court. Now, looking at our scenario back here at home, would you say that our approach is a carrot and stick affair, given our performance appraisal system?
So, thank you. First, let me start by saying that before the performance, the PMMU was rolled out, there was an engagement of stakeholders, one of who were members of the judiciary and judiciary staff. In the report that was produced by Justice Musinga, the question of reward took some prominence. I think the majority view was that those who did well needed to be rewarded. I think less pronounced in that debate is whether those who did not do well needed to be censured. Again, less pronounced was what is the manner, what is the carrot? Is it monetary? Is it recognition? Is it acknowledgement? I think that in the end, the manner in which we have used the carrot is one that has been agreed through engagement by those it affects. The manner of acknowledging, which the Chief Justice does often, outstanding members of staff, judges who have been exemplary, is, as I see it, effective way of rewarding excellence and good performance. Respecting the question of the stick, the manner in which we do it, it needs to be sensitive. It must not be in a way that in fact kills the spirit of those who are underperforming. It must be one that balances understands why someone is underperforming, one that encourages and sets out measures for improvement, yet one that the underperformer must be let to know that he's not pulling his or her weight in service delivery or in carrying out their functions. So generally, yes, I would agree. I think it is effective enough. There might be times when we will change that. I am aware that, for instance, because I have Gen Zs in my house, they might view these very differently. They are very open about certain things. They will tell you when you're wrong, when you're right. It might reach a point where they will say, if you're not performing, you take a pay cut. If you're performing, you are awarded or compensated in monetary. I am sure that a day will come when that conversation will be on the table.
Yeah, now that you bring out that angle, and taking your answer in totality, essentially, you agree that our approach to performance appraisal is the carrot and stick affair. Out of the proposals you've made, or even the observations you've made, it's not really worked in terms of motivating performance. The stick aspect, that is, has not really worked in terms of motivating performance. You have scenarios where someone feels nimefika. So what else is there to work hard for? So they don't work hard. As an institution, there is every effort to facilitate everyone. The remuneration is not so bad, maybe not ideal, but not so bad. But still, we have those scenarios of people who simply will not pull their weight no matter what. So around here, we've had conversations around Article 168, Sub-Article 1D, the question of incompetence. The argument being failure to meet performance targets is incompetence. I don't know what your view will be about that. It's rather controversial, but I would want to hear what you think about it.
168.
168, 1D, basically incompetence as a ground for removal.
Okay. Yes. Commissioner, I thought you were talking generally about judicial officers and judiciary staff, not just judges. So in respect to judges, I think the Constitution speaks clearly and loudly. I'm trying to recall whether that section has been used to set up a tribunal which investigates a judge. It doesn't. I'm not too sure it has.
Not strictly speaking, no.
Yes.
It has not, but it's a thought.
It's a thought.
I just wanted your take on it.
Yes. Given the criticism that the judiciary has to deal with daily, online, when you meet people, when you have interactions about certain whether we are suffering a question of competence and capacity, I think I'd leave it to the Commission to have that debate. The Chief Justice, as the head of the judiciary and also as the chairperson of this commission, they might need to see whether in future it can be invoked. But the caution perhaps is that how does one measure incompetence? Where it is obvious and where it is clear, then I do not see why it cannot be a measure or a reason for removal of a judge. Otherwise, to say it isn't is to say that that provision of the Constitution has been put there and it is idle and it should never have been. But the challenge is to the Commission the challenges to the Commission. We will give our views
Okay.
when invited.
Okay, thank
All
you.
right,
Thank you, Judge, and I wish you well.
Thank you.
Lady.
Thank you. Commissioner Zirani?
Thank you, Honorable CJ. Good afternoon once again, Judge.
Good afternoon.
It's okay, you can go ahead and take your water.
Yes, thank you.
You're good to go?
Yes, I am.
Okay. I will start you off with a quote, and then you'll tell us your understanding of the quote and give us your views on the same now that you want to ascend to the Supreme Court. It's a quote by a U.S. Supreme Court judge, and he says, the Supreme Court is not final because it's infallible, but it is infallible only because it is final. The Supreme Court is not final because it is infallible, but it is infallible only because it is final. What do you understand by this quote? And maybe you give us your views on the same.
Okay. Now, the Supreme Court is the apex court in the country. It makes difficult decisions with far-reaching consequences. It speaks with authority. It sets precedents. Now, notwithstanding that it is a final court, there will be occasion when a further reflection of a decision made today reveals a rethink. When that occasion arises, and there might be many or few, the Supreme Court must reflect as to whether a mere change of mind should lead to departing from a past decision it has made. This is because, as the apex court, cognizance of its importance in that ladder, it is expected that the Supreme Court will have given deep thought to the decisions it makes, and there shouldn't be too much occasion for revisiting a decision made. This gives stability to the law. It allows members of the public, there is then predictability as to organize themselves, knowing that this is the position of the law in certain aspects. So, yes, the Supreme Court is not infallible. And this is not just in respect to the Supreme Court of Kenya. In America, for instance, on the question of the abortion question, Roe versus Wade, there had been immediate debate as to whether the judges themselves were right or wrong in that matter. And the debate can be as soon as the next day or the week after. But I think the position that the Supreme Court took was that there is value in stability. Let a matter settle. Let there be widespread debate before you change your mind on the matter. I say this, nevertheless, aware that if there is a matter that is glaringly a wrong position, then the Supreme Court should be able to presented with a situation where it requires to rethink its position, then it should do so. But it should not be within reviewing the matter itself. Now, when the second part was, if you could just say that, the quote again. So
the second part was your views, and I think you've already given that.
Yes.
What do you think of the quote?
The second aspect of the quote.
The quote says, I read the quote again?
Yes, please.
Okay. The Supreme Court is not final because it is infallible, but it is infallible only because it is final.
It is infallible only because it is final. I think that when you're placed in the position where you have the last word, and where your word is the law in certain respects, it puts you as well in a position of vulnerability, because when you make a decision that eventually revisited many years later is one that you should not have made, then you did not have the opportunity for an immediate second look, but you've had yourself to deal with it later. I've tried to thread the needle there. I'm not sure I've done it. Yeah.
All right. My second question, please describe a situation in your career where you had to take a position in a judgment, ruling, or public stance that conflicted with your personal beliefs, your political views, your personal and professional relationships, or your social environment, and tell us how you handled the situation and perhaps any lessons you learned from the same.
Mm-hmm. You'll allow me not to give specifics, because I don't to reveal who I have disappointed and who I have not, okay, or to really, if you'd allow me to
pass that
yes. No, but I want to say how I could possibly, I have dealt with it.
Okay.
I've had absolutely no difficulty. And because in respect to the opinion of others, I have tried to be clear in my views as to why I arrive at a certain decision. I shun from explaining myself, even when invited by those who thought that I should have gone a different way in a matter. I invite people to look at my judgment and to interrogate it. It's slightly different where you have an eternal conflict where your decision goes against what you strongly feel about. I haven't had many of those, and I take it to be different from the situation asked by Commissioner Lady Justice Njokindungu in respect to where the outcome of the decision or the reading of the law and facts is not in consonance with your sense of justice.
Okay. Yeah. Finally, for me, it would be a follow-up from Justice Njoki's question on where you do not agree with members of your bench when making a decision. Should a Supreme Court judge write dissenting opinions, or does dissent undermine institutional collegiality and the court's legitimacy? Maybe you'd also tell us what the implications of writing these dissents would be.
Thank you. A judge ought to write a dissent where they feel strongly that it is required. It must not be on minor, what one would say, disagreements on insubstantial issues. The value of a dissent is that it invites a more holistic debate on a matter. It brings out different perspectives regarding an issue, and no doubt a good thing for the growth of jurisprudence. Is dissent then one that is in conflict with collegiality? Not at all. In fact, if you have a strong view which you refuse to express in an opinion when you ought to, then it does not, you're not being open about your position. Dissents, when they are properly worded and where indeed there is real occasion for or need for dissent, can enhance collegiality. As judges, we should be able to express the differences of opinion freely and openly, candidly, and knowing that we are all members of the court accountable jointly to the people of Kenya. And if a dissent will enrich jurisprudence, then I'll take it that in fact you are promoting collegiality. You are enabling your brothers and sisters sitting in the same bench to be able to be more accountable to the people of Kenya.
Okay. Would there be concerns if the dissents were coming from one judge and if they were frequent?
It might be a reflection of judicial philosophy. In fact, if there is a judge who holds a certain judicial philosophy and is feels very strongly about that philosophy, dissenting in circumstances which reflects that philosophy is a good thing. It is an attribute to the judge in respect to the consistency in which they approach matters.
Okay. Thank you, Judge, and I wish you well.
Thank you.
Thank you, Commissioner Kiswata.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you.
I want to take you to a softer area now that you have sat on that seat for over 3 hours.
Oh my.
But we are not very far from concluding now. Could you tell us what ethical challenges might a Supreme Court judge face? And you could also share with us your proposals on how to overcome such challenges in the event that you are successful in this bid.
Ethical challenges. Over time, the judges in the past, those who've gone before us, have developed certain principles that try to put us as judges in the straight and narrow, starting from the Bangalore principles, and then for us, the code of conduct. When you're faced with certain ethical challenges, I think your grey book ought to be the code of conduct. That should be the starting point to see how to address those questions. That would be my short answer.
Now, there's a question you were asked earlier on by Commissioner Olwande on performance, and I would want to hear how you will deal with a situation where you are part of a bench where one judge consistently delays judgments, of course, causing a delay in delivering of justice. What steps would you take?
Thank you. The presiding judge in the bench, one of your responsibilities is to whip up members of your bench in terms of performance of their work. If I was the presiding judge, it might be easier for me to remind my colleagues who are falling back in a respectful manner on how to deal with delayed judgments. It seems, nevertheless, that a better way might be to set out together as colleagues a framework for checking on each other as to when one falls behind. You could agree that a manner of reminding one another as to a decision that has delayed, so that the reminder is not seen as a censure, is not seen as disrespectful, but the system that you have prescribed yourself to, itself reminding you that you are underperforming. It may seem to be a difficult question, but if you do it in a respectful way and trying also to understand occasion when there will be real difficulty or real reasons why a decision has been delayed, if you try and interrogate it, then you might find that you are able to deal with it. I know, for instance, that there are times when a judge, for some reason, has been unable to churn out a decision either out of illness or out of the complete difficulty of a matter, and has discussed it openly with members of the bench, and one other judge takes up the task. So there are many ways of dealing with it.
Mm-hmm.
Yes, thank you.
Okay. Now, Article 232 of the Constitution calls for both equity and meritocracy. How would you resolve a situation where affirmative action objectives appear to conflict with this, with the strict merit base?
Mm-hmm. The provision of affirmative action in the Constitution is a recognition of historical reality. And so the framers of the Constitution were deliberate about addressing certain inequalities, whether they be gender, regional, ethnicity, and so forth. And the provision is there deliberately in the law, in the Constitution, to deal with that. The question would be whether in implementing affirmative action, whether it should always trample on merit. It's a balance that one has to walk, because the Constitution does not have conflicting provisions. They must be implemented in a manner that is harmonious, that one supports the other. If I was on the implementing body, I would have to try and devise a manner in which to strike a balance. For instance, in respect to, and this is one way, in respect to whether someone falls short of merit, yet there is a question of affirmative action, I think it would be wrong to only apply the question of affirmative action when it is glaring and it is not explainable that a person who falls so much short of merit should be given a certain position. It's a difficult question, but one must bear those parameters in mind.
Okay, thank you. Thank you. I wish you well, Judge.
Thank you. Vice Chair.
So it's afternoon now?
Yes.
Are you tired?
No.
Oh, yes. We can do a little bit more. So what is the role of President at the Supreme Court? And what factors lead to possible revision of the same?
The role of President. Now, the manner in which the Constitution sets out the role and mandate of the Supreme Court, it declares very clearly that the Supreme Court, the decisions of the Supreme Court are binding to all other courts. And once the Supreme Court has made a decision in respect to a matter, then the other courts are obliged to follow the principles in that decision. The value of a precedent, I may have mentioned this earlier, is that it brings predictability on the law, so that one is able to understand their obligations, their rights, and can be able to predict almost accurately that a question I put before the courts could either go this way or the other. I don't know that I have addressed your the second aspect.
Yes, or we can leave it.
Okay. Sorry, if I don't want to leave anything unturned. Yeah, the second aspect.
I was just wondering for how long is it valid?
Oh, how long?
Is it eternal, or what factors could lead into such revision?
Yes. If you'd allow me just to repeat myself, I think the Supreme Court should be slow in deviating from its past decisions unless there is extremely good reason. And that calls for a heavy responsibility of the judges of the Supreme Court, so that they are careful that the decisions they make can stand scrutiny and can stand the test of time.
Okay. All right, then what does judicial independence mean to you?
Judicial independence. Judicial independence. There might be two limbs to this. Indeed, there are two limbs to this. The question of institutional independence, which Commissioner Deputy Chair, this commission is very important in terms of safeguarding. Institutional independence would mean that the recruitment of judges and the work of the JSC is truly independent, the funding of the judiciary, and so forth, those that speak to the institutional independence. Then there is the individual independence of judges, one that is safeguarded by our tenure of office, the manner in which we are recruited, and our solemn oath of office not to be influenced in any manner by external factors in the manner in which we discharge our duties.
Okay, thank you. Thank you.
Thank you very much.
Yeah.
Thank you very much, Judge and Commissioners. I think this now brings us to the end of a very long interaction and deliberations with you this morning. But before we finish, we always give a candidate also an opportunity to engage us. So the floor is yours.
Thank you. Can I just, if you'd allow me, just to take this opportunity to thank you once more for this chance that the Commission has given me. I am also aware that there'll be people who will be following on YouTube. And just allow me, my lady, the Chief Justice, to just thank, in a special way, members of my family and all the colleagues, particularly the Court of Appeal, who see me as the quiet team member lifting his weight quietly in a corner and needed to be urged on to apply for this esteemed position. Let me thank them very much. Sorry. A little emotional there.
Thank you very much, Judge. On behalf of the commissioners, we wish you well. We wish you success in all your endeavors. You are one of us, whichever the case. Therefore, we like to really encourage our candidates to keep up the hope. I think now we are finished. You are discharged.